Welcome back to the channel. One of the greatest privileges I have of running this channel is when I get emails from you guys to tell me that somehow or another my videos have helped you to overcome a problem, resolve a dispute, or even in quite a number of cases you've won your case in court with the guidance and just tips and tricks that I help to provide on my channel. So I'm very humbled by those comments and I'm very grateful to receive them, and it's just great to hear that these videos have that effect and help you to resolve these issues without the expense of a lawyer. Ironically, me saying that as a lawyer. So in this video, I thought I would address this again because lots of people ask me, is there another resource or something you can sit and read to understand how court trials work and how to conduct an examination of another party, let's say if you're doing it yourself? Because even if you're in a small claim, you can conduct that cross-examination yourself. Even criminal trials, and some fairly famous criminal trials just recently, where the defendant, him or herself, is permitted to cross-examine other parties. So if you are in a small claim, you can cross-examine another party. And so welcome back to the channel, but if you are new to me, I'm a barrister who helps you understand law. And in this video, I'd really like to introduce you to a book which I think is probably the single best book I've ever found on advocacy training, and I certainly recommend it to anybody that I know that is on the bar course training to be a barrister. As you might know, I am a freelance tutor on the bar course, primarily teaching advocacy skills and submissions skills. Submissions are like an application in court. Let's say you're applying for an injunction and these kind of things. And so this book is called The Devil's Advocate, and I'll link the book in the description below. It is an affiliate link for full disclosure, but this is a fantastic book. I have read it countless times, and I would absolutely recommend anyone that's got any interest in law whatsoever to read this book. And particularly if you have a case that you're trying to deal with yourself, it will help you to understand how courts will look at disputes. It will help you to understand how evidence is considered and all of these kind of things. It's written by Ian Morley, who is now King's Counsel, then Queen's Counsel when writing this third edition. He's a barrister practicing in criminal law from chambers at 23 Essex, which is a famous set of chambers. He was based at London. But also in April 2009, he was appointed as senior trial counsel at the UN Special Tribunal for Lebanon, and has a great many other accolades which you can read about in his About section. The contents of this book go right from learning advocacy, a discussion on the truth. So whether you are seeking the truth or whether you're seeking to win a point, that's an interesting point covered in this book. Then something all about winning, because you may have heard the phrase that it is all about winning for a barrister. And indeed, that is one of the concepts that we live by. The cases are about winning. We do everything we can to win within the rules. The tribunal psychology, so how a tribunal, being either a judge or a jury, so whichever tribunal, the finder of fact, the decision makers, how they think, what they are looking for, and how to be persuasive. And then it moves neatly on in chapter 6 to persuasiveness and how to be persuasive. For example, if you want somebody to believe something, you don't say, you must conclude this. To be persuasive, you would say, based on this, and this reason, evidence, logic, fact, and reason, you may conclude that this is the case. You may conclude that I am right. And this is one of the ways of being persuasive. There are times when you can tell people that they must conclude something. That's when you're saying that there's irrefutable evidence, and if you find this, you must conclude that. That's when there's a legal definition. That's something interesting covered in this book as well. Case preparation, he talks about addressing the judge, legal writing, document management, opening speeches, which is a particularly interesting chapter, but then also some of the chapters that you will find particularly interesting if you are trying to handle your own case. There's a chapter on witnesses, there's a chapter on questions, examination in chief, and cross-examination, and many, many more chapters. 27 chapters overall. So in this video, I'm just going to run through a brief snippet preview from the examination in chief section And then if you find this interesting, I urge you to go and buy this book and read it yourself. As I say, the link is in the description below. So this chapter begins, and I agree, by saying, some say this examination in chief is the most difficult skill. And in some jurisdictions, it's called direct examination. And it is more difficult than cross-examination. And there's an important reason why. And it talks about it in this book, but I'm going to give you my views as well. So you can read about it in this book, and my views are as follows. Many students that I find, they seem to think that chief examination is going to be easier than cross-examination, because cross-examination you need to have a strategy, whereas chief, it's your client usually, and you're getting your client to tell the story. However, you can only do that with non-leading questions. So, for example, if it was a dark night, you can't say, was it a dark night? Because that's a leading question. You are suggesting the answer inside the question. Even if you are giving choices, you need to be careful that in the choice you are not suggesting the answer. For example, if you give lots of detail in one of the choices, it's clear that you're leaning to one of those choices and you're providing what you believe should be the answer in that question. And skipping on a few pages, it talks about the golden rules for chief examination, which are the types of questions that you use to try to ensure that they are non-leading questions. And it's typically who, what, where, when, why, how, and describe or explain. So if you are using who, what, where, when, why, how, and describe and explain, they are typically an open question. How did this happen? Who was it? Where was it? Why was it? How long was it for? How long did you do that for? Can you describe what the person was wearing? And there are some examples in this book, and it talks about creating a foundation to build your story. So I'll give you this little snippet, but then I'm not going to spoil any more, and you can buy the book and read it yourself. But it's a most fascinating but very, very easy read. For it's not a legalese book at all. It's a very nice, easy read, but it explains all of these concepts to you. So creating a foundation in an open chief examination or direct examination, you may begin with, who were you with? And the answer is a man. The next question, please describe that man. The answer might be, he was quite big. So then you can go into a bit more detail with the question. When you say quite big, was the man tall or short or average height? So now you're narrowing down the answers, but you're still leaving it open. The answer might be, he was taller than average. So if he was taller than average, you can then focus in on that answer because you've been given the information. You can then say, was the man tall then? And the answer will be yes. So you've got to the answer that the man was tall, but without leading on that information. You've been given the information by giving them the choice in the first instance. Was the man tall, short, or average? So you've gone for both extremes and right in the middle. And the answer can say, well, taller than average. And your next question then is, so was the man tall then? And the answer, of course, will be yes. And you're laying this foundation. You're building the picture of what this person looked like. The next example talks of lighting, because as my example, you can't just ask, was it a dark evening when this happened? You need to have open questions to elicit that answer and the information from the person in the witness box. So you might ask a question such as, what was the lighting like? Which is a very open question. The answer might be, there was street lighting, but it doesn't really tell you whether it was light or dark at that point. So then you can use a closed word choice question, which gives both suggestions, but allows the witness to give you the information. Was it light, dark, or dusk? So again, you're giving a few options to choose from, and the witness will give you the answer. It was dusk, the witness says. What distance could you see? This is again an open question, because of course how far you can see might determine what the level of lighting is like. 10 meters. What could you see over that distance? Again, very open question. I could see the burglar. What of him could you see? Open question. I could see his upper body. Could you see his head? That's eliciting a yes/no answer. Yes. What could you see of his head? And so you see, digging for detail and detail upon detail with what started as a very open, foundation-laid set of questions. So just to follow on from anyone that has their own case coming up and you are planning to represent yourself and you're here on my channel for some guidance, I love to get your feedback when this works for you, but I would also love to see what you think of this book, because I would say this should very much be compulsory reading for anyone who is on the bar course, because this is such a fantastic advocacy book, and so I will link it in the description below. That was an example of the chief examination. You'll be particularly interested in the cross-examination if you're representing yourself, because you will want to represent yourself by cross-examining whoever's bringing the claim or any witnesses against you. And it also talks about what the court is looking for, what kind of evidence they're looking for, how to be persuasive, not just going in there to argue your point that you are definitely right, but persuasion in your points to convince somebody that your argument is right, not just you, because you need to take out the emotions and you need to take out the opinions, unless of course you're bringing in an expert opinion, in which case it's valid. But generally the court is not interested in opinions and emotions, unless it's an offence, a criminal offence that relies on, let's say, the emotion of fear, because that is in part to robbery, which distinguishes robbery from standard theft. There's the fear of violence, and then, of course, emotions play into it. But generally, no opinions and no emotions. But I thought that I would bring this to you because it's been a while since I've mentioned this book on my live stream. So I hope you enjoy it. Please let me know how you get on with it. Please like this video. Remember to subscribe. I'm teetering very, very nearly on 250,000 subscribers, and I'm getting quite excited about that. Probably a little bit too excited, but hey, here we go. And also check out my Black Belt Secrets channel in the description below, where I'm going to be talking a lot more about how to save money and how to make money and how to just be more positive in life in general, because we're in for a rough few months, and I'm going to be here with you on that journey. I'm going to be here to keep you positive, because that's what I like to do with everybody in my life. I like to keep people positive, people happy, and share the knowledge and wealth that I have built up over many years. So please subscribe to Black Belt Secrets in the description below, and thank you for watching.